Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley, and I'm joined again today by one of our star attorneys on the team here at Beermann, Jordan Rosenberg. Jordan,
Thanks for
welcome.
having me, James. Appreciate it.
You bet. So, Jordan and I, in thinking about some topical discussion points, we thought, what better than to start the conversation regarding back to school? And it happens to be very topical because I will be driving one son back to Indiana University this week, and then next week one to the University of Illinois. So
my alma mater.
Absolutely. So you can speak to that. And
Yep.
I think there's a lot of things around college that parents hopefully right now are not dealing with and have already dealt with at some point in the future as part of their agreements. But as a starting point, Jordan, just when you deal with a divorcing couple or a couple that's already divorced, at least in Illinois, what's the starting point in terms of the question, who pays for college?
Right. So there's a section in the Illinois Marriage and Dissolution of Marriage Act that deals with this specific issue. And basically one party has to petition the court and say, hey, I want the other person to contribute to college. And this is an interesting discussion that we've had on another podcast where, is it an automatic? Do you automatically have your parents pay for college? Does the other person automatically have to contribute? That's a really interesting issue. But basically what it is you ask the court, you say, Judge, my child's ready for college. I have expenses A, B, C, D, tuition, room, board, so forth and so on. How do we pay for this?
Okay. And that can be a petition you would file either as part of an ongoing divorce, or the parties could have been divorced many years ago, and a typical provision in a marital settlement agreement just simply reserves the question because, for example, if it was 7 years ago the parties got divorced, it would be speculative as to whether the children will go to college, how much it will cost, what college they will attend.
Right. I mean, we even have cases where the child is 2 years old or 16 months old.
Sure.
Where we kind of throw in that standard language that says, well, if, as and when the child goes to college, then the issue of payment is reserved. And so just going back to your point, coming back now 17 years later, 16 years later, they show us this old MSA or marital settlement agreement and say, hey, there's no provisions for college. How do we deal with this? Yeah. And that's what James was saying is you file your petition, you ask the court.
Gordon, talking about perhaps some divorce decree that would have done 17 years ago. 17 years ago, there weren't the statutory restrictions. It could have been, kid is going to go to Harvard or Yale or whatever the cost is. That wasn't something that was statutorily governed, but that's changed in the last couple of years.
Correct. And that change has been pretty monumental because how it used to read was the court would just look at a certain number of factors and they'd say, well, what's the financial ability of mom, dad, partner, spouse, and even the child, if there's amounts that are set aside for the child. But now the court kind of limits that inquiry and says, well, the cost of college is capped at the University of Illinois in Champaign-Urbana. And so public in-state tuition there.
Right. And
so even if your child goes to Harvard and it's $80,000 a year, the court says, I'm only capping somebody's obligation up to the University of Illinois in Champaign.
And that's the distinction. It's not that the child can't go to a Stanford or a Harvard, that very expensive schools. It's just that legally, the court's only obligating the parents to that in-state U of I tuition as the benchmark as to what they would be obligated for.
Right. And the court not only can order the parents to contribute too. So the court can also order the child to contribute. And it's interesting because if you look at it, it caps that U of I. And so if you take into consideration scholarships or something like that, and do you count that as the child's portion? Do you count that as resources available to the child? How does that, in your mind, how does that go into the inquiry on who pays for college? Something, if it's a scholarship that takes it above the U of I cap, but with the scholarship would bring it back down.
Yeah. And I think that's, from my experience and our experience in litigating these issues, the general consensus we've gotten from the courts is that they're looking more at that price cap, as opposed to your point, if you're going out of state, such that the out of state tuition would be $20,000 more than in state at U of I, but then the kid gets a $20,000 scholarship, we're right back to the costs that it would have been had he gone or she gone to University of Illinois at Champaign.
Right. So I've seen it a couple different ways. I've seen it where, they say that the $20,000 scholarship is actually the child's portion.
The contribution.
Right. And so they say, okay, well, mom contributes, 30%, dad contributes 30%, and the child's portion, taking into consideration that discount is the balance of the percentage.
It's interesting that what I particularly like, and this is probably more personal commentary than anything legal, I came from a background where my folks didn't have the resources to pay for my college. So I put myself through college and law school. And I think there's a bit more of a trend. A lot of judges now, they're putting some onus on the child in these circumstances to at least pay a percentage of their own education, or take out a loan, or do something where they're contributing somehow to their own educational costs.
Right, but where does that money go, right? And if you're going to the University of Illinois, of course, you have to join a fraternity or sorority, right? Like me.
Well,
and you have to study abroad, right? And you have to, get your gold meal plan and go to, Red Lion and all the bars. I mean, are those college expenses? And of course, if you're going to U of I, those are necessities.
Right. Well, and these are conversations that took place in the Quigley household with my oldest, when my son decided he wanted to be in a fraternity. And, whatever your position is on that, and I know you're a big fraternity guy, there's a cost to that.
Right.
Right. And so, to your point, do mom and dad have to pay for that? I mean, that was a conversation in-house I was able to have with my wife. But if you're divorced or going through a divorce, that's a decision that the court may make for you if you can't figure that out on your own.
And maybe not, right? And so the statute, it lays out specific like concepts that can be contributed to. And so it actually sets a cap at standard, I think it's 2-bedroom housing with like a standard meal plan. And so what does that cost? And if it goes above it, does the court say, no, you can't pay for it, or you shouldn't be obligated to contribute to it? Should it be the child's responsibility, right? And these are all things that are above and beyond that aren't encompassed in the statute, like, the $10,000 a year fraternity dues that, again, are a requirement.
Yeah. Well, you've got those issues. And then, like you said, even studying abroad. It's interesting because my son, having done that, goes to Spain. I was a little, same way. I was thinking, well, how much is this going to cost?
Right.
It actually was less expensive because I think of the housing or whatever it was, the credits turned out to be less expensive. And so, these are things that sometimes going into the beginning of college, you may not even have it on your radar that 3 years from now, your son or daughter may say, hey, I want to go study abroad, have no idea how to manage the costs. So one of the things you want to think about, to the extent you can, even in crafting a marital settlement agreement, is let's anticipate some of these expenses.
Right.
The statute does some of that as far as travel back and forth. If your child is, at a school at someplace, they'd have to take an airplane to come back.
Yep.
But trying to think ahead to some of those expenses and deal with that as part of an agreement is probably a good idea.
Right. I mean, think of your next son that you're going to send off to college, right? There's reasonable move-in fees. That's not accounted for in the statute. There's furnishing an apartment. That's not accounted for in the statute. Of course, he needs his new Jordans, and that's not accounted for in the statute, or even any clothes. I mean, stuff like that, the extras aren't accounted for in the statute, and therefore the court doesn't have the authority to order that. But those are real expenses that, back to school, those are important. That's important stuff.
Yeah, that's it. It's last night I literally handed my credit card to my son because I'm hoping he doesn't get new Jordans, but he said, Dad, I need new tennis shoes. Yep. I need this. And those are reasonable expenses. Now, if I were divorced, is that something child support would pay for? And that's what we run into those issues. By the way, even the move-in fee.
Right.
So you move in on this date, but if you want to get there a little bit early, like my son does, and there's some kind of engineering stuff and they get to go to these things before school starts, great stuff. By the way, it's an extra $150.
Right.
So what are you doing? You're going back to court and you're saying, hey, my ex owes me $75.
Right.
But those costs add up. And to your point, they're not necessarily, every cost isn't delineated in the statute. So it's a little ambiguous.
Right. And to your point, that's why we try to build in as many costs as we possibly can so that there isn't this guessing game and this wiggle room. And so, of course, even though the court can't order it, doesn't mean that two people can't agree to it.
Right.
So if two people agree to including these expenses, then two people can agree as to how to divide them.
That made me think of one thing that we see from time to time, which makes this conversation a little bit easier this time of year when kids are going off to college, is where people do have educational plans. And one of the things we do routinely, and the courts are always supportive of this, money that's set aside for children during a marriage is not going to be touched. In other words, in theory, it's still marital money, right? The kids don't own that account with $100,000 in it. But the courts are going to preserve that by and large. And we generally try to bake that into our settlements where that's set aside for the kids. Let's leave it for the kids. And at least you've got a couple of years taken care of where we don't have to have this fight.
Right. And actually, I just recently ran into an interesting issue on how to apply college expenses. And so some of those expenses that we were just talking about, like fraternity and sorority dues, move-in fees, clothes, school supplies, that's not encompassed in this, like the tax code, those can't be paid for by 529 funds. So it's interesting because a lot of agreements that we see say, you know what, just exhaust the account before anyone has an obligation to contribute. But in reality, there are some of these other expenses out there that can't be covered by 529 that still have to be subject to division. So when we're talking 529 accounts, we're talking about these Bright Start accounts or accounts that are set aside for children to go to college. So very generally, tuition, room and board, fees, books, stuff like that can come out. But again, some of these extras, you may not even legally be able to touch that based on the tax code.
Yeah. And I think the interesting thing to think about is if you're in the process of getting a divorce now, is there a way you can predetermine this stuff so that when you're in the situation where I am today, where you've got a couple of kids going off to college, you really would like to avoid the stress of having to try to figure things out now. We have some cases that are in court. We've got tuition bills that come due and kids are sitting there trying to figure out, am I going to be able to finish out the semester if mom or dad doesn't, pay my bills? So trying to balance that, hey, we've got really young children in a divorce and not knowing what tuition is going to be versus waiting till the 11th hour. It's August and we got kids going back to school. Let's fight about it now. Somewhere in the middle is ideally where you'd want to try to resolve this.
Absolutely. I mean, a lot of people, that's sort of like the last in a marital settlement agreement, especially if you have young children. It's one of those things that you just kind of punt on very routinely. And you say, you know what, we'll reserve it. It's fine. Our child's 5 years old. We can come back. But to the extent you can pay some attention to it like we do, and you can, again, just sort of mitigate some of this conflict and, preemptively address these things, that's huge. Sure. Because every judge looks back to the judgment and says, well, you guys agreed to this. Yep. So if we're fighting about fraternity and sorority expenses and it's in your judgment that you drafted 12 years ago, it's a no-brainer.
Thinking too, some of the creative ideas we come up with in these settlement agreements is sometimes there's a friction between mom and dad, one party not wanting to pay more money to the other spouse that they're divorcing, and that's completely understandable, right?
Right.
And so sometimes what we've done in trying to be creative is build into the agreement, like you said, you got a 2 or 3 year old child, not going to be going to college for a decade and a half. Let's build into the agreement that while there's a child support payment and we deal with who pays for extracurriculars and medical and all these other expenses as the kids are growing up, let's also build into the agreement that each party is going to pay into a educational account to the tune of $100 a month, right, or $250 a month or $500 a month, something such that what we're really doing is we're just paying over time. It's something we likely would have done during the marriage anyway, and sometimes you can do it where mom sets up an educational plan in her name, dad sets up in him, and it's court ordered though that each will make those contributions.
Right. I mean, it's like forced savings, right?
Right.
And so to that end, you can even say, well, off the top of the division of the marital estate, maybe we set aside X number of dollars, right? And if there isn't a 529 account, so if everybody's getting 50-50 of the estate and there's $100,000 in a bank account, if we could be so lucky to have that, maybe you skim off 25,000. You say, listen, let's separate this. Let's put it into a 529 account. or let's put it into some, account in both our names that requires both of our signatures and earmark that for college.
Yeah. We've actually done well in some situations where, there is a fight, and it doesn't have to necessarily just be about child support on a monthly basis, but like you said, sometimes even with assets, or sometimes someone's claiming something to be non-marital. Maybe there's some legal challenge to that because contributions were made, and it's going to be a sticky legal issue. And to your point, you say, well, I'd rather peel some of that off and give it to the benefit of my children in an educational fund, as opposed to giving it to my soon-to-be ex-spouse, who I believe doesn't deserve what I'm claiming was my money. So being creative with some of the disputes and shifting it over to the kids, knowing that there's a large percentage of children by the time they get to that age, they're going to be going to college. And as far as I can tell, college isn't going to be getting any cheaper, pending your political affiliations, I suppose.
Well, how about this one? So the statute also provides that during periods of recess, right? So you say support to the kids, and it goes directly. During periods of recess, like summer or winter break or something like that,
Yep.
The court can say that the parent who the child doesn't stay with during that time could actually pay some form of support to the housing parent.
Mm-hmm.
So, if two people were divorced and, son comes home from college, stays with mom, dad may actually be required to pay a couple $100 a month for quote unquote child support during this period.
Yep.
And so, that is another consideration that's sometimes overlooked. That is, it's sort of like, we kind of use it most times as like a bargaining chip, I think.
Yeah.
Where it's just a couple $100 a month, but it's still, again, it's where it's so unclear, but how do you kind of draw that line?
Yeah, those are really hard because number one, you don't want to put the child in a position where he or she's coming back from college after freshman year saying, and by the way, there's no parenting agreement at the time or
Right.
allocation judgment. There's no child's 18 years old or older, can live wherever he or she wants.
Right.
So dad all of a sudden kind of offers up a kind of a nicer option for the child.
Right.
So he doesn't have to pay during the summer. But like you said, sometimes what we try to do is horse trade and say, listen, we've got this fee that's going to come up for your fraternity fee.
Right.
Here, you pay that. I'm paying the expenses of our son or daughter during the summer months. Leave it alone.
Right.
Because candidly, what you get into, and you reference sort of a couple $100, certainly could be more depending on the incomes of the
Right.
parties. But when you convey that against legal fees paying us to petition the court, to go in, fight about it, oftentimes you end up spending more in legal fees than what you end up recovering. And that's a hard piece too, because you want to have the support, you want to have the help in defraying the food costs, and hey, they're driving the cars, you get your insurance and your gasoline and all that kind of stuff. And but at the same token, you always, and this is something we talk with our clients all of the time, you have to do the opportunity cost analysis and say, what's the value of paying attorneys to go into court, fight on these issues? Because even if you win, sometimes you spend the same amount that you actually won in court, and all you've done is created acrimony and stress.
Right. And right now in court, we have a case where there's a $1,500 medical bill for a 19-year-old freshman in college. And so the question is, do you hire a lawyer and fight about it to recoup 50% of that, the $750,
Mm-hmm.
or do you just say, what, like, I'll eat it and I'll hold it for later, and obviously I'll document it, but these are, it all goes down to just how you can cooperate with the other parent.
Yeah.
And if it's one of those things where you're going to nickel and dime each other, then you're going to have to make these tough decisions and these sacrifices. But hopefully you're in a situation where, you want what's best for your child, and you guys are aligned in how you're going to raise your child and how their college experience is going to be, and you won't have to run into those. But again, I think we're kind of sort of pessimistic understanding what we do.
Well, and with good reason. Anecdotally, we literally tried a case where our client's son went to school. He had some mental health problems.
Yep.
And, sort of had a breakdown, was not able to continue on in school, had to sit out a semester or two. And the way the agreement was reached and the statute is written, if you're not in school on a continuous basis, then the parent's obligation can go away. So the dad in the case even though, so the son recovers, he's doing well, gets himself a little job, wants to go back to a community college.
Yep.
And the cost of the community college was like a few $1,000s.
Right.
And dad fought it tooth and nail. We literally had a hearing. The parties probably spent in legal fees combined 3 times the amount
At
of
least.
they could have paid for the son's last 2 years of community college,
Right.
and still come out ahead. But in that case, dad was just standing on principle.
Yep.
He was so angry and couldn't see it any other way.
And you know what? He points to this one specific provision of the agreement, and he goes, "This is what I agreed to. This is what I negotiated," which literally leads us back to the same lesson that we always teach our listeners at the end of each podcast: is make sure you are careful with how you're drafting, and make sure that what it says is what you mean. And while you can't provide for every single scenario, I think those are ones that are, pretty foreseeable. Like, God forbid something happens to your child during college and they have to sit out for 6 months, make sure that language is in there that says your obligation continues, if with good cause.
Yeah. Or build in some kind of reasonableness provision that contemplates some of the unknown, because I don't know that anyone really, expects that going into college, my son or daughter is going to have, some kind of breakdown, even though the stress on these children today is just, it's ridiculous. It's so much different than, when I went to college years and years ago. But, so maybe those kinds of things are a little more foreseeable. And those are the kind of things that the last thing I think you want to do is put your child in a position where, because something unforeseen happens to him or her, that mom and dad have written you off, you're on your own, even though you're working your way back into a position of really trying to get yourself on track and get your education and really better yourself in life. That case was really heartbreaking.
Yeah.
And it was a waste of money.
Right.
So some interesting things. I think just one last thing I'd like to talk about too, in terms of, that we're focusing on back to school. This is the time of year. With some of the changes here in Illinois that I like, another one is sort of an emphasis on the grade point average of children and really holding them to account for their performance. And that's something that kind of tied in with that case we dealt with as well.
Yeah.
But again, if someone's grades plummet because they're having a mental or emotional breakdown, that's sort of a different scenario than when I went to school and, the kid across the hall who's, came in with the big floor speakers and he partied every night and, a semester later he had flunked out,
Right. But what about your roommate?
Touche.
Yeah. Right.
And so, I think that some of the concepts that, at least in Illinois, the legislature has built into the statutes is really, hey, mom and dad, we're placing an obligation on them financially, which for me as a married individual, no one can order me to pay for my kids' college. Right. And, it's really interesting because you have people who are getting divorced that if they were married, they might've said, listen, son, daughter, mom and dad don't have the money. You're going to have to take student loans, or you're going to have to join the military or get a job for a period of time. And so you're putting a burden on parents legally. And at the same time, they're sort of saying, but the child has to have some skin in the game, maybe paying a little of his or her own education, having to maintain certain grades. So it's not just a one-way street, and the kids, have to have some accountability as well.
And I mean, sometimes we build into our agreements and judges order. I mean, it's, the child is responsible for 20%. The mom is responsible for 40% and the dad is responsible for the balance. I mean, it's not just mom and dad. And like I was saying earlier, is the court can allocate some of that burden on the child, which would mean maybe taking loans or getting a job and working during school. And that's sort of the issue that's in, I think it's the Supreme Court right now, is on this issue of 513 and the constitutionality of it. And is somebody entitled to have their college paid for if their parents are divorced? And so that's a really interesting issue that is, it's recent and it's up in the high court right now.
And that's been bandied about in conversation for a long time, because I've had clients who've actually asked that question: how can I be made to do this? And as a married couple, you're not. And I really think that the statute is well intended, because they're trying to promote an obligation, to help kids get their education. But it's not a guarantee, and I'm not so sure that it is constitutional that the legislator can mandate that upon divorcing parties. Um, and we see that in the context of, sometimes there are parents who literally do not have the ability to pay, $50,000 to $100,000 a year for education expenses.
Right.
And what happens? They have to take the parent loans.
Right.
You've got to pay a third, you got to pay half, you got to pay 25%, whatever it is. We've got a client right now, and she just does not have the financial ability, but she's got, and it's a minor percentage of the total, but she has a percentage that she's obligated to pay. I think the only realistic way that she's going to be able to manage those costs are her taking a parent loan. So she's going to have to go in debt.
Yeah, it's something that obviously needs to be addressed, and I think the Supreme Court's trying to address it now. I guess we'll see. About it. Yeah.
But listen, this is otherwise it's a very exciting time of year. A lot of transition. If you have children that are getting ready to go to school or go back to school, the enthusiasm and sometimes a little bit of an anxiety that goes with it. So we certainly hope that, if nothing else, this kind of discussion allows you to plan in advance. If you're not there in the throes of it right now, think about these things. Try to, as best you can, step back from whatever the conflict is in the divorce, which is not always easy. And maybe try to think about August of 2020 or August of 25 or August of 2030. When your young child may be going off to school, how can we find a way today to avoid having that, problem or issue come up somewhere down the line?
Last question.
Yeah.
If for our listeners who have marital settlement agreements that have that reserve language, when would it be appropriate to ask the court to for college contribution?
That's a great question. I literally had a case where I had a client whose child was in his sophomore year of high school, and we brought a petition because the child was already knew where he wanted to go, what he wanted to do. The judge in that case found that the petition we filed was not ripe, meaning it was too early. Now that's a discretionary call, but from my standpoint, having gone through this with my kids, senior year, they're applying to college. They've taken the ACT, the SAT, and that type of thing. So, in a lot of students, in the summer before even sophomore year, certainly summer before junior year, sometimes, and most definitely before their senior year, you're taking those campus trips. You're going to different universities, trying to figure out what's what. So, I think personally, you absolutely sort of beginning of the child's junior year of high school should really be reaching out to your attorney or to us and say, hey, listen, I was divorced 10 years ago. My son or daughter just started, junior year of college, going to be starting the ACT testing. We did some, summer trips, looked at universities. What do we have to do? Because at some point within that year, you'd like to try to reach out without filing a petition. Right. Maybe contact the other side's attorney and say, hey, listen, this is going to be coming up. Let's button it up well in advance so that the child's senior year, the summer after senior year, is stress-free. Mom and dad know their obligations. They can start planning, paying for it. By the way, we can look at what funds are available. Yep. So it's a great question. There's no exact answer, but the last thing I think you want to be doing is finding yourself in court the summer before your son or daughter are going to go off to college, because it's just going to create extra anxiety. You're not going to have the opportunity to prepare yourself financially for it. All those financial forms, FAFSA, and all that other just crazy stuff that you have to do, even to be eligible for financial assistance.
Yeah.
All has to be done in advance. So good question. Do this stuff in advance. I hope this is informative, and hope that if you're like me and you have kids going off to school this time of year, that you enjoy the memories of that and all goes well. Thanks again for listening. Thanks to Jordan Rosenberg.
Thanks for having me.
If you ever need to reach out to us, you can reach us at 312-621-9700, or check us out online, www.beermannlaw.com. Thanks for listening.
Thanks.